my lordship, I will not take my lordships through most of those points because they've already been argued by my learned friends. My lordship, I only want to make 2 or 3 core points.
What is it? Can you formulate them?
Yes, I'll formulate it, my lordship. My lordship, my first point is that eligibility is a completely different compartment of rights, duties, and obligations as opposed to suitability. I just want to distinguish that.
No, Manjushri, there's no dispute on this.
Yes.
Manjushri also clarifies that.
That's right.
You don't need to.
Yes. So here, my lordship, I just wanted to just take my lordship through. I won't take my lordship through the case law, but if my lordships may only look at Pawan Verma, my lordship, that is in Mr. Hansaria's compilation as well. In volume 1, I would just take my lordship straight away to page 239 to paragraph 14 and 28, my lordship.
In support of what proposition?
This, my lordship, on the point of fact that the interview, my lordship, I just want to distinguish to the fact that the suitability, my lordship, at the end of the day, one of the thoughts which bothered my lordship in the last round was how do you give a certain amount of fair play at the joints? How do you distinguish or how do you bring in some level of fair play by which, like Justice Narasimha sir rightly pointed out, that pleasure doctrine, how do you give that little bit of a leeway where the suitability can be adjudged and the best of people can be taken on board? My lordship, here, just to continue with the formulation.
You're showing us some page,
Yes.
240.
Paragraph 14, my lordship, has at page 252 of the compilation of Mr. Ansaria.
252. PDF 252 only.
My lordship, this is essentially on the suitability aspect from the Justice Sikri Committee report, my lordship. I won't bother reading it out. Should I read it out to my lordship, or this is one point, my lordship, in paragraph 28.
What is the judgment you're referring, Mr. Kuriakos?
My lordship, this is Pranav Verma. Pranav Verma's judgment, my lordship. Registrar General of the High Court of Punjab and Haryana, my lordship.
Para 25.
Yes, my lordship, 20, 28 and 29, 25, I won't take it, my lordship. So my lordship has already seen that. 28, my lordship, the proposition which I want to advance is only this, my lordship. If the, as regard, may I read that, my lordship?
Yes.
As regards the petitioner's plea that marks of the main exam should be disclosed before conducting viva, we are of the considered opinion that such a practice may not insulate the desired transparency. I'm sorry. My lordship, para 28 at page 257, my lords. So Ansaria's compilation, volume 1. My lordship, Justice Roy has it. This is paragraph 28, my lords.
Yeah.
My lordship, I'll just read from the third line. I won't take too long. My lordship, the broad principles to be laid down in this regard must be viewed keeping in view the selection for various categories of posts by different selecting authorities. For such a self-evolved criteria cannot be restricted to judicial service alone. If the members of the interviewing boards are already aware of the marks of a candidate secured in the written examination, they can individually or jointly tilt the final result in favor or against such a candidate. The suggested recourse, thus, is likely to form bias affecting the impartial evaluation of a candidate in a viva voce. The acceptance of the plea of the petitioners in this regard will also run contrary to the authoritative pronouncement of this court, Ashok Kumar Yadav versus State of Haryana. As a written examination assesses knowledge and intellectual abilities for a candidate, the interview is aimed at assessing their overall intellectual and personal qualities. Any measure which fosters bias in the minds of interviewers, therefore, must be done away with. My lordship, I'll just stop there. Only to reiterate that point, my lordship, that if the two compartments are kept separate and the interviewing board has no access to the marks which a candidate has received in the written examination, then you have a ring fence, my lordship. There's a firewall to the extent that I will not be aware about what comes.
Normally, the interview board doesn't have the marks which are scored in the written examination.
That's right. But in some of the case law which my lordship has seen, my lordship will see that case law, Ashok Kumar Yadav is a case law where they've gone to that and examined the malafidis to say that yes, there is some malafide. But the challenge here, my lordship, is when the viva voce comes in and the question of how do you aggregate the marks. Now, if the suitability part, my lordship, at the end of the day, any authority needs some level of free play at the joints. Now, the free play at the joints, my lordship, is what has troubled all these benches till date. Those rules of that game, how do you look at that 5% of that very narrow conspectus, which ultimately is where this entire litigation is centered around. That is just, in my humble opinion, my lordship, it's a very small percentage. How do we lay down a broad kind of an interpretation by which ultimately that question can be tackle, like my lordship pointed out, without arbitrariness coming in as a test in that stage. So how do we do it at the procedural level under the procedure established by law? My proposition, my lordship, was to keep it both completely separate to the extent that eligibility is from a large pool of students. There could be 20,000 people say, applying for a job, out of which ultimately my lordship will see that 200 or 300 finally make it for the Viva.
All right. Now, what is the next point? What is the next
The next
point?
proposition, my lordship, is indebted to my friend Hari. I was just discussing that point, my lordship. I would like to take my lordship straight away to Ramchandra Iyer's judgment, my lordship, paragraph 44. The
What is the
proposition
point?
is this.
What is the point that you are
The
making?
point is this, my lordship. The rule has to provide with absolute specificity, and it cannot be by necessary implication read into a rule, my lordship. The prescription has to be absolute. The prescriptive authority, whatever is being said, cannot be assumed by silence to make the transition. So it has to be something which is absolutely certain and which can be pinned down to something which is transparent, and the rule of law should be completely tangible in that sense.
Rule must be clear and certain. Okay.
Yes, the
Noted.
rule must be clear and certain.
Clear and certain.
Yes,
Next.
my lordship, the Ramachandra Iyer's judgment is paragraph
There.
44.
All right. Then,
Yes, there, my lordship, at paragraph 44, 48 and 49 are those
what
prepositions.
is the third proposition?
Yes, the proposition, may I show that to my lordship once? The proposition is that the rule has to be clear, not by necessary implication. You
Make
cannot
the point.
bring in, yes, you cannot do something indirectly, what you cannot do directly. At the end of the day, whatever has to be done has to come in through that particular way. My lordship, the third point is, at the end of the day, my lordship, I won't take my lordship through the case laws which I've enumerated, I put it there. But one of the points, my lordship, which was vexing us while we were discussing and deliberating on this matter, was also about the remedy. Where do we go for a remedy? Now, my lordship, one of the points we very
How do you formulate it actually?
Yes.
What is the formulation?
There, my lordship, the formulation would be this: can some form of ADR, I wouldn't say, my lordship, an ADR this process, but just in terms of the guidelines which my lordship was saying, what is possible at the end of the day in addressing these issues. One of these issues, my lordship, will see, since there's no indefeasible right, whether at some stage an ADR mechanism for each of these high courts when it comes to these kind of matters, my lordship, because that essentially there has to be some place at which the rights can be ventilated. And these duties, at the end of the day, the rights not
So
be.
what ADR mechanisms will the high courts follow in a competitive selection?
Public law.
Some
Exercise of power
kind of
is the ADR.
some kind of a provision, my lordship, in the sense that either it has to fall back ultimately in a 226 jurisdiction of
Noted.
public law.
All right.
Yes.
What's the last point now? Fourth point?
My lordship, the last point is again on the same principle of arbitrariness, which I won't take, my lordship. I'll just rely on my written submissions for that. The point is only to reiterate legitimate expectation as a factor which goes into these aspects before the crystallization of
That is
rights.
completely wrong.
All these points I've taken it. I won't trouble my.
All right. Thank you, Mr. Kuriakul. Thank you. Thank you.